Welcome to Personal Injury Marketing Minute.
Welcome to the Personal Injury Marketing Minute, where we quickly cover the hot topics in the legal marketing world. I'm your host, Lindsay Busfield, Vice President and Partner over at Optimize My Firm. Today, I'm joined by Mark Melrose of Melrose Law, PLLC, and Mark has more than 35 years of experience handling personal injury, wrongful death, and complex litigation. His firm is currently focused on cases in Western North Carolina, especially those that involve impaired driving and the serious harm that follows. Today, we're talking about the real value of DWI cases, including the different types of impairment involved and how these cases differ from standard car accident claims. Thank you so much for joining us today, Mark.
Well, thank you for having me.
Well, tell us a little bit about your firm and about yourself and how you got started.
So I've been practicing and living in Western North Carolina, went to undergraduate here at Western Carolina, and have been practicing law in the westernmost counties in North Carolina, all the way Asheville, Hendersonville, West. I decided almost 35 years ago to focus on personal injury cases, medical malpractice cases, legal malpractice cases, and do a lot of motor vehicle and trucking and motorcycle collisions. And I had at one point a larger firm. We had 6 lawyers, and then circumstances changed and I downsized, and eventually my son decided to go to law school out of Melrose. And so he's been practicing now with me as a partner for 8 years plus now. And so we practice together and we handle most all of our cases jointly, so that each case has 2 lawyers essentially working on the case.
And that's great to be able to lean on all the experience that you have and be able to work with your son to build even better cases and handle them well together. And clearly, from your years of experience, you have seen countless numbers of motor vehicle accidents. And with those, you see a lot of similar causes between them, whether it is inexperienced driving or driving while distracted or driving on dangerous roads at too high of a speed. But today, we're here to talk about driving while impaired. And this is a huge problem, especially when it comes to our youth in the area. So young drivers who are in their 20s and 30s, but really any sort of driver out there. But let's focus in on these cases. From your perspective, what kinds of impairment are actually showing up most when we're talking about serious DWI injury cases?
I think most are alcohol related, but with now, I mean, we see also drugs, whether legal or illegal drugs combined with alcohol, can have, a synergistic negative effect where the impairment is enhanced. People may or may not be aware of that. Sometimes they take more than one substance in order to get the enhanced high or impairment. So the law enforcement has a very difficult time detecting substances other than alcohol without a blood test. Alcohol is by far the most prevalent substance that law enforcement charges arising out of a wreck.
Right. And what is it that makes it so difficult for law enforcement to be able to differentiate between somebody who is driving while under, the influence of alcohol versus combining that with, say, cocaine or fentanyl or whatever it is that they are combining to get that high?
Law enforcement is very familiar with testing people roadside sobriety tests, and the Alka-Sensor handheld device to be able to check somebody's blood alcohol levels been around for 30 years probably at this point, and that's a very easy test for law enforcement to be trained in to test. The problem arises when somebody may not have the odor of alcohol, may just be exhibiting other signs of impairment, either stumbling, slurring, not being, physically uncoordinated, not making sense. In order to the officer can form an opinion that they're impaired, and that may be sufficient to take the case into court. It may not be sufficient to get a conviction. In criminal court, we focus on the civil side, and we can talk about the fact that there's a distinction. But in order to definitively prove that the defendant driver is impaired by a substance other than alcohol, typically requires a blood test. And that requires more effort, more time, and there's chain of custody issues and things like that. So you don't see as many people charged with simply being impaired due to, for example, being impaired by marijuana or cocaine or something like that.
And from a case evaluation standpoint, Does it matter whether somebody is impaired with just alcohol or if there are other chemicals in their system?
From the standpoint of pursuing a case in civil court for damages, the source of the impairment is not is it's important but not necessary to be able to prove what, for example, if somebody's impaired by alcohol and also impaired by some other substance, all that we have to do is prove that more likely than not that they were impaired at the time of the collision and that the impairment was what we call a proximate cause or a real cause of the collision. So it's actually easier in civil court to win a case showing an impaired driver was the cause of the collision than it is in criminal court. Criminal court has a lot more rules and requirements regarding the admissibility of certain types of evidence. In civil court, we can use the officer's global opinion that the defendant seemed impaired, plus we can use results of alcohol tests or blood tests, but it's not as critical in civil court.
So there's not a huge distinction between what they're impaired with. But let's talk about the difference in case types between somebody who is sober and causes an accident versus somebody who is impaired and causes an accident. How does that change how you approach developing your case?
From the very beginning, in terms of case intake and evaluation, we want to figure out what was the cause of the wreck and what were the surrounding circumstances. In North Carolina, we have to show, again, more likely than not, the defendant was the cause of the collision. And typically that involves showing that they violated some motor vehicle law, stop sign, traffic signal, left of center, failure to yield, something like that. So we need that failure to use a duty of care, a motorist duty of care. If there is impairment, and oftentimes on the intake process, we learn, that the defendant was charged with driving while impaired. That immediately gets our attention because if there is impaired driving, generally speaking, the case has significantly more value than if the exact same collision had occurred without the impairment by the defendant. So it's the difference between what we refer to as negligence versus gross negligence. So negligence is somebody making an ordinary mistake, not seeing that the light was red, failing to see a car that was coming, something like that. But if you take those exact same actions and you determine that the defendant was impaired, then there's essentially a multiplier effect on the damages that you would expect to recover because of the impaired driving.
And so would that damage multiplier be in terms of punitive damages?
Yes, that's correct. So compensatory damages are the damages you get in a personal injury case for any type of injury or damage. So that typically involves medical expenses, past and future, lost income, pain and suffering, scars and disfigurement. And those are considered compensatory damages. And the purpose of compensatory damages is designed to make a person whole, to reimburse them for the money they paid the doctors, what they've lost from work, etc. And when we have impaired driving, you are entitled to not only recover for compensatory damages, but then the jury is also instructed and able to award extra damages that are called punitive damages. And those are generally only available in cases involving gross negligence, the most common source of gross negligence in North Carolina being impaired driving. There's some other examples, such as, kids that are drag racing or engaging in some other really aggravated reckless conduct. But the idea that somebody makes a conscious choice to drink and then drive allows the jury to use punitive damages. And we can talk about what the purpose of those damages are, if you'd like.
Sure.
So punitive damages, as I said, compensatory damages are designed to reimburse or make whole the plaintiff for the harm that's been caused. Punitive damages can be assigned and awarded by the jury against the defendant to make an example out of the defendant to the community, that the community does not tolerate drinking and driving. It can also be used to punish. The jury can punish the defendant. And so we see juries typically being quite generous in damage awards involving punitive damages because as a society, we're well informed at this point that drinking and driving is dangerous, it's bad, it's wrong. People still choose to do it. So if you get 12 reasonable-minded citizens on a jury, they tend to view drinking and driving, particularly when it causes physical harm to somebody or death, they tend to view that very negatively, and they can become quite angry and award substantial damages.
So in these cases, it sounds like the best course of action is taking it to trial if you are seeking out those punitive damages from the jury. Is that always the case, or do you tend to? Are there any instances where it's in the best interest to settle before going to trial when it comes to DWI cases?
Right. So we know if there's strong evidence of impaired driving that the case has more value than the same case without impaired driving. The insurance companies also know the same thing. And I tell all my new clients when we first talk and we're doing the initial interviews that, my goal as a personal injury attorney is not to take their case to trial. I'm skilled and able to do that, and we do it from time to time, but the majority of cases settle. And the reason why these cases settle, including impaired driving cases, is because the insurance companies also know that since juries place a higher value on impaired driving cases, they will, generally speaking, and frequently do, offer to settle for more than you would expect and or up to policy limit. So it is not uncommon, even in a modest case where the injuries are not that serious, when the insurance company knows that for a basic liability policy, they may have to pay their whole policy, including punitive damages, they tend to be engaged in settlement offers that are more generous. And often you can get the case settled with that in mind.
Well, it sounds like that, at least from a trying a case perspective, that is one advantage to working some of these cases and marketing towards getting some more of these DWI victim cases. But what are some of the specific challenges that tend to surface when building these types of cases that a firm who hasn't tried as many of these might not anticipate from the onset?
I think recognizing the distinction between a criminal conviction, which is unnecessary, and a civil damages case where we can go to trial on an impaired driving case, knowing even that the defendant was acquitted or was never prosecuted for impaired driving. And we've been successful in cases where you can have opinions. In fact, I recall one case not too long ago where the defendant ended up not being charged with impaired driving, but one of the officers at the scene thought he should have been charged, was upset about it, and ended up being a witness that we were able to use to be able to demonstrate that there was a law enforcement opinion that the defendant was, and the legal term of art is appreciably impaired. So you can also prove impairment through lay witnesses. If you have lay witnesses, and this happens from time to time, they say the defendant got out of his car after the collision, wasn't making any sense, appeared to be stoned or high or impaired. Those opinions are admissible because we all know, as just average people, whether we have medical training or law enforcement training, we know how to recognize somebody who's impaired. And that all started in college or earlier. And so we can use those same opinions and present those in court, and juries can take those into account to determine whether they believe that the defendant was impaired. A whole lot easier with a law enforcement opinion, but not critically necessary.
Right. And with law enforcement, you would think that they would be specialized in being able to determine whether somebody is impaired or whether they're having a mental health crisis at the time of the collision.
And they generally get it right. Sometimes it just depends. Sometimes if the collision is serious enough and the defendant is injured and removed by EMS from the scene, sometimes they don't get the alka sensor, and sometimes they don't collect the evidence. There's more of an immediate need to make sure everybody survives the collision and gets health, emergency medical treatment. So sometimes the evidence is lost. And we can also go back and find out through discovery, where had the defendant been, who had he or she been with, had they been drinking, how much had they had to drink. And so you can engage in discovery. And also people now with text messages tend to send all kinds of messages before and after collisions that inculpate them with regard to drinking. I mean, we have one right now where the text messages are essentially a gift to the personal injury attorney that they were sending, among friends before the collision.
Right. Having photos of people taking shots and saying they're so wasted is probably kind of a gift.
Right. This one was they were joking about day drinking before they invited my client to go on a ride with them, and she had no idea that they had been day drinking. So she was just a passenger. So
Yeah. Well,
yeah.
and you would think that when it comes to DWI accidents, there could be several variations within the case and several people who could be liable. How does Dram-Shop liability play into North Carolina? Does North Carolina law recognize that as a liability?
It does. Dram shop cases are very difficult to prove because you do have to figure out where had the person been, and that the bartender, say in a local bar, had should have known that the person was substantially impaired and continued to give them alcohol, and it was foreseeable that the person was going to get in a car and drive. That's often very challenging to prove, but it does happen from time to time. I mean, it requires a lot of effort and discovery in order to figure out where had the defendant been, and had they been drinking? If so, how much? How many drinks have they been served? And it's helpful. I mean, if you have a case with catastrophic injuries, you're always looking for some other coverage or insurance policy or defendant who might have a deeper pocket. A lot of the people that drink and drive are carrying minimum policy limits or no policy. And so we run into cases with uninsured drivers. And there is a distinction between the recovery of punitive damages from a liability carrier on the initial liability policy versus underinsured coverage, where you cannot collect punitive damages. So it's better to have more money on the liability side if you have a punitive damage claim.
That makes a lot of sense. So, for firms who are thinking about marketing towards DWI cases and bringing more of those in, what should they understand about the commitment that these cases actually require? Do they take longer? Do they take more effort?
I think overall they take more effort and more attention to discovery. Although some cases are just very easy. If there's clear liability, the defendant's charged with DWI. Maybe by the time the plaintiff calls our firm, the defendant's already been convicted. Well, that's a pretty easy case. They've already pled guilty. They've been convicted. The evidence has already been collected and proven essentially by law enforcement. So I think that you know, that requires more effort in terms of discovery for a case, and also a question of whether the defendant is really has demonstrated any level of remorse or regret for causing the collision and causing the harm. So, for example, a case we're handling right now with impaired driving, the defendant pled guilty in the criminal case eventually, and still denies that his drinking was a cause of the collision. He, wants to have his cake and he could eat it too. So in that case, it requires a lot more effort, depositions, pinning the defendant down, and really in these cases, hoping from the plaintiff standpoint that the defendant refuses to accept responsibility for the harm that was caused. The more resistant the defendant is to accepting responsibility for hurting somebody because they were drinking and driving, the more punitive damages the jury's going to lay on to them. So, from a plaintiff standpoint, that's better. Of course, it goes, you have to weigh that against, how long will it take to get to trial and what's the difference in recovery and that sort of thing. But yeah, we want defendants, as a society, we want them to be remorseful. As a plaintiff's attorney, I'm fine when they're not, as long as I can prove that they were drunk
Right.
or
And,
impaired.
and in the long run, the more punitive damages that are placed on them hopefully will keep them from repeating these actions, and that they will spread the message of it's just not worth it to get behind the wheel when impaired.
Right. And I think, that's the goal of punitive damages. Like I said, to make an example out of them, to punish them, to use the community's sense of outrage and to turn that into an economic award against them. So, and it does get people's attention, and particularly if it's bad enough and large enough, the media may pick it up, and that's also helpful.
Well, and of course, the primary goal would be to cut down on these types of accidents. And I know that your firm is advocating to reduce the amount of DWI accidents, DUI accidents in Western North Carolina, and so much so that you have started a scholarship that is geared towards teens and students, spreading the message to their peers to help cut down on these types of accidents in the community. Can you tell us a little bit about that scholarship?
Yeah, so we decided to establish this Melrose Law Community Scholarship, $2,500 to a high school graduating senior um, who comes up with the best 45 to 60 second long YouTube type of message that they produce and create, not AI generated, but that they actually creatively produce, that is designed to capture the attention of other young people, to point out, the harms of driving while impaired, and how preventable this type of collision is. I mean, there will always be motor vehicle collisions, trucking accidents, etc., where people just make ordinary mistakes. They're not careful. It's raining, whatever. There's circumstances. We're just not all perfect in how we drive and we go through life. And if we don't use reasonable care, we're responsible for the harm that's caused. And that's, as a society, the choice we've made. With drinking and driving and impaired cases, the choice is made when they get behind the wheel, because the odds are that the collision would not have occurred if they didn't make that conscious choice to drink and drive. So we're hopeful, if we can get the message to young people as they are learning to drive and getting out on the roads, that, that any other option short of getting behind the wheel is preferable, then that will be successful. And, the goal of the scholarship is just to raise awareness. And, if we prevent one collision, which it's always hard to quantify something that didn't happen, but if it's at all helpful, then we're glad to do it and help somebody get on their way, get a little help for college.
So thank you so much for joining us today to discuss this important work that you're doing. And that will wrap up today's episode of the Personal Injury Marketing Minute. If you want to learn more about Mark Melrose and Melrose Law, you can find them at mountainverdict.com. And if you're a personal injury firm thinking about growth and positioning more in a competitive market, you can reach out to me at optimizemyfirm.com. Thank you so much for listening. And don't forget to like, leave a review, and subscribe to the show so that you don't miss our next episode.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.